Duffy would be able to answer. Now we move on to warnings from DOD. Around this period in late July and early August, Duffy also ignored warnings from DOD about the legality of the freeze. The Senate should hear from him and judge what he has to say. Throughout July and August, Duffy executed President Trump's freeze of the military aid through a series of funding documents from OMB. In carefully worded footnotes, OMB tried to claim that this, quote, was a brief pause, and it would not affect DOD's ability to spend the money on time. As we now know from public reporting, as the freeze continued, DOD officials grew more and more alarmed. They knew the freeze would impact DOD's ability to spend the funds before the end of the fiscal year. DOD officials, including Deputy Undersecretary McCusker, voiced these concerns to Duffy on multiple occasions. First, in an email on August 9th, McCusker told Duffy DOD could no longer support OMB's claim that the freeze would not preclude timely execution of the aid for Ukraine. Her email read, and I quote, "As we discussed as of 12 August, I don't think we can agree that the pause will not preclude timely execution. We hope it won't, and we will do all we can to execute once the policy decision is made, but can no longer make that a declarative statement." Then again, on August 12, McCusker warned Duffy in an email. The footnotes needed to include a caveat that, quote, "execution risk increases continued delays." The House never received these documents from OMB or DOD. We know what they contain because of public reporting, despite persistent efforts by the Trump administration to keep them from Congress and the public. The Pentagon's alarm should have raised concerns for Duffy. Did he share DOD's concerns with anyone else? Did he agree with those concerns or take any actions in response? Did he take direction from Blair, the White House, or President Trump? These questions that Duffy should answer. Despite his actions executing the president's freeze, Duffy internally expressed reservations about it. In August, he signed off on a memorandum to Acting Director Vought that recommended releasing the aid. That memo stated the military aid was consistent with the United States national security strategy in the region, that it served to counter Russian aggression, and that the aid was rooted in bipartisan support in Congress. This is contrary to Duffy's actions leading up to the memo. What changed? What caused Duffy to disagree with the president's direction to continue to withhold the aid? Duffy should be called to explain why he recommended that the president release the aid, what other steps he took to advocate for the release. Does he know why Vought and the White House apparently disregarded the recommendation? Based on public reporting, we know after the press reported the freeze in late August, OMB circulated talking points, falsely claiming, quote, "no action has been taken by OMB that would preclude the obligation of these funds before the end of the fiscal year." According to public reporting, McCusker responded with an email to Duffy to tell him that this, quote, was just not accurate, and that DOD had been, quote, consistently conveying that for weeks. Due to the public release of these emails and recent reporting, we also know that Duffy emailed McCusker on August 30th and told her, there was a clear direction from POTUS to continue the freeze. McCusker continued to warn that the freeze was having real effects on DOD's ability to spend the military aid, and the impact would keep growing if the freeze continued. According to recent reports, around September 9, after the president's scheme had been exposed and the House had launched its investigations, Duffy responded to McCusker's warnings with a formal and lengthy email. He asserted it would be DOD's fault, not OMB's, if DOD was unable to spend funds in time. Deputy Undersecretary of Defense Elaine McCusker reportedly responded, "I am speechless." We now know that DOD's concerns were well-founded. The president's freeze on the security aid was illegal. Duffy should be called to testify about why DOD's repeated warnings went unheeded. What prompted his email that attempted to shift blame to DOD, and about the fact that the president released the aid only after his scheme was exposed. Senators, make no mistake. We have a detailed factual record showing the freeze was President Trump's decision, that he did it to pressure Ukraine to announce the political investigations he wanted. But President Trump's decisions also set off a cascade of confusion and misdirection within the executive branch. As the president's political appointees carried out his orders, career officials tried to do their jobs, or at the very least, not break the law. Blair and Duffy would help shed more light on how the president's orders were carried out. That is why committees of the House issued subpoenas for both of their testimony. But Blair and Duffy, as I said earlier, like many other Trump officials, refused to appear because the president ordered them not to appear. And I might add, as a former judge, I have never seen anything like this before, where someone is ordered not to appear by one party and the witnesses just don't appear. The United States Senate should not allow the president and his administration to continue to evade accountability based on these ever-shifting and ever-meritless excuses. We need to hold him accountable because no one is above the law. Nadie está encima de la ley. Nadie. Blair and Duffy have valuable testimony to offer that the Senate should call upon them to do their duty by issuing this subpoena. Mr. Chief Justice, the House managers reserve the balance of our time for an opportunity to respond to the President's argument.
Ms. Bondi?
Honorable Senators, just to fact correct, please, a few things. Mr. Duffy didn't come from a state job. Mr. Duffy came from Deputy Chief of Staff at DOD before he went to OMB. Big difference there. Manager Garcia said he failed to appear. Well, the House committee would not allow agency counsel to appear with Mr. Duffy or Mr. Blair. They would not let agency counsel appear with either of them. Office of Legal Counsel determined, of course, that the exclusion of agency counsel from House proceedings is unconstitutional. It's a pretty basic right. So what did they do? They took no action on the subpoenas. But now they want you to take action on them. The managers have been telling you all day, the House managers all day, White House is trying to hide from American people what witnesses had to say. They've been saying we want to bury evidence, we want to hide evidence. That hypocrisy is astounding. They've been saying, let's not forget why we are here. Well, we're here tonight because they threw due process, fundamental fairness, and our Constitution out the window in the House proceedings. That's why we're here, because they started in the secret bunker hearings where the president and his counsel weren't even allowed to participate when they're trying to impeach him. Intel and Judiciary Committees was a one-sided circus. Ranking Member Nunes asked to call witnesses. He explained why in detail. It was denied by Manager Schiff. Ranking Member Collins asked to call witnesses. Denied by Manager Nadler. And that's what they call fairness. That's not how our American justice system works, and it's certainly not how our impeachment process is designed by our Constitution. The House took no action on the subpoenas issued to Mr. Duffy and Mr. Blair because they didn't want a court to tell them that they were trampling on their constitutional rights. So now they want this chamber to do it for them.
Thank you. The House managers have 24 minutes remaining.
Mr. Chief Justice, a couple fact checks once again. First of all, the complaint is made, well, the House wouldn't allow agency counsel. Why wouldn't the House allow agency counsel to be present in those secret depositions that you have been hearing so much about? And as I mentioned earlier, those secret depositions allowed 100 members of the House to participate. There are 100 members of the Senate. We could have had that secret deposition right here in the Senate floor. But during those depositions, members of both parties were given equal time to ask questions of these witnesses. Now, why not allow an agency counsel? And by the way, where did Democrats get that rule of no agency counsel during these depositions? We got it from the Republicans. This was the Republican deposition rule. And we can cite you adamant explanations by Trey Gowdy and others about how these rules are so important that the depositions not be public, that agency counsel be excluded. And why? Well, you'll get a good sense of it when you see the testimony of Deputy Assistant Secretary George Kent. Kent describes how he's at a meeting with some of the State Department lawyers and others, and they're talking about the document requests from Congress. And what are they going to do about these, and what documents are responsive, and what documents aren't responsive. And the issue comes up of a letter that the State Department sent to Congress saying, you're intimidating the witnesses. And Secretary Kent testified, no, the Congress wasn't intimidating witnesses. It was the State Department that was intimidating witnesses to try to prevent them from testifying. And so my colleagues at the other table say, why aren't you allowing the minders from the State Department to sit next to those witnesses and hear what they have to say in the depositions? We've seen all too much witness intimidation in this investigation to begin with without having an agency minder sitting in on the deposition. And by the way, those agency minders don't get to sit in on grand jury interviews either. There is a very good investigative reason that has been used by Republicans and Democrats who have been adamant about the policy of excluding agency counsel. It was also represented that the Intelligence Committee and the Judiciary Committee wouldn't allow the minority to call any witnesses. That's just not true. In fact, fully 1/3 of the witnesses who appeared in open hearing in our committee were minority-chosen witnesses. Now, what they ended up having to say was pretty darn incriminating of the president, but nonetheless, they chose them. And so this idea, well, we had no due process, the fact of the matter is we followed the procedures in the Clinton and Nixon impeachments. And they can continue to say we didn't, but we did. And in some respects, we gave even greater due process opportunities here than there. The fact that the president would take no advantage of them doesn't change the fact that they had that opportunity. And finally, the claim is made that we trampled on the constitutional rights by daring to subpoena these witnesses. How dare we subpoena administration officials, right? Because Congress never does that. How dare we do that? How dare we subpoena them? Well, the court heard that argument in the case of Don McGahn, and you should read the judge's opinion in finding that this claim of absolute immunity has no support, no substance. It would result in a monarchy. It is essentially the judicial equivalent of don't let the door hit you in the backside on the way out, counsel. There's no merit there. And counsel can repeat that argument as often as they like, but there's no support in the courts for it. There should be no support for it in this body, not if you want any of your subpoenas in the future to mean anything at all. I yield back.
The majority leader is recognized.
I have a motion at the desk to table the amendment, and I ask for the ayes and nays.
Is there a sufficient second? The clerk will call the roll.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
Does any senator wish to change his or her vote? If not, the yeas are 53 and the nays are 47. The amendment is tabled.
Mr. Chief Justice,
The Democratic leader is recognized.
I send an amendment to the desk to prevent the selective admission of evidence and provide for appropriate handling of classified and confidential materials, and I ask that it be read. It's short.
The clerk will report.
The senator from New York, Mr. Schumer, proposes an amendment numbered 1290. On page 2, between lines 4 and 5, insert the following. If, during the impeachment trial of Donald John Trump, any party seeks to admit evidence that has not been submitted as part of the record of the House of Representatives and that was subject to a duly authorized subpoena, that party shall also provide the opposing party all the other documents responsive to that subpoena. For the purposes of this paragraph, the term duly authorized subpoena includes any subpoena issued pursuant to the impeachment inquiry of the House of Representatives. The Senate shall take all necessary measures to ensure the proper handling of confidential and classified information in the record.
The majority leader is recognized.
Mr. Chief Justice, we'll now take a 5-minute break. I'd like to ask everybody to stay close to the chamber. We'll go with a hard 5 minutes. I ask that we stand in recess subject to call of the chair.
Without objection, so ordered. The Senate will come to order. Mr. Schiff, are you in favor or opposed or?
In favor.
Favor. Mr. Cipollone?
Mr. Chief Justice, we are opposed.
Thought that would be the case. There are 2 hours for argument, equally divided. You may proceed first.
Thank you,
Senators, the Majority Leader amended his resolution earlier today to allow the admission of the House record into evidence, though the resolution leaves the record subject to objections. But there is a gaping hole, another gaping hole in the resolution. The resolution would allow the President to cherry-pick documents he has refused to produce to the House and attempt to admit them into evidence here. That would enable the President to use his obstruction not only as a shield to his misconduct, but also as a sword in his defense. That would be patently unfair and wholly improper. It must not be permitted, and that is what the Schumer amendment addresses. The amendment addresses that issue by providing that if any party seeks to admit for the first time here information that was previously subject to subpoena, that party must do a simple and fair thing. It must provide the opposing party all of the other documents responsive to the subpoena. That is how the law works in America. It is called the rule of completeness. When the selective introduction of evidence distorts facts or sows confusion in a trial, there is a solution. It is to ensure that documents that provide a more complete picture can be introduced to avert such distortions and confusion. The rule of completeness is rooted in the common sense evidentiary principle that a fair trial does not permit the parties to selectively introduce evidence in a way that would mislead fact finders. The senators should embrace it as a rule for this trial, and the amendment does just that. This amendment does not in any way limit the evidence the President may introduce during his trial. He should be able to defend himself against the charges against him, as every defendant has the right to do around the country. But this amendment does make sure that he does it in a fair way, and that his obstruction cannot be used as a weapon. It is an amendment based on simple fairness, and it will help the Senate and the American people get to the truth. House managers are not afraid of the evidence, whatever it may be. We want an open process designed to get to the truth, no matter whether it helps or hurts our case. That is what the Senate should want, and that is what the American people certainly want. This amendment helps that process of getting more evidence so we can get to the truth, and we urge you to vote for it. The amendment also addresses another omission in the Majority Leader's resolution by providing for the proper handling of confidential and classified information for the record. This amendment seeks to balance the public's interest in transparency with the importance of protecting limited, sensitive information bearing directly on the case you are trying. As for confidential information, some of the evidence in this case includes records of phone calls. They establish important patterns of conduct, as we explain in the Ukraine impeachment report. But the original phone records, including a great deal more information and context, should be available for this body to review if needed in a confidential setting. It contains personally sensitive who are not at issue in this trial and would potentially subject them to intrusions on their privacy. The Secretary of the Senate has the capacity to handle such material and make it available to you as needed. The amendment allows the privacy interests of many individuals to be protected while allowing senators access to the full record. As for the classified information that this amendment addresses, there may be several very relevant classified documents. Let me just highlight one in particular. It involves the testimony of the Vice President's National Security aide, Jennifer Williams, and it concerns a conversation between the Vice President and the President of Ukraine. And the House managers believe that it would be of value to this body to see in trying the case. Let me start by saying that we have twice requested that the Vice President declassify this document. We have reviewed it, and there's no basis to keep it classified. The Vice President has not responded. We can only conclude this is an additional effort by the President to conceal wrongdoing from the public. But as it stands now, it remains classified. It must be handled like any other classified document by this body, and the amendment would allow that. But let me just take a moment to go further. The public should see that supplemental testimony as well. That supplemental testimony, that classified testimony, was added to the record by the Vice President's aide because she believed, I think on further reflection, that it would shed additional light than what she had said publicly. And you should see it. You should evaluate it for what it has to say. But what's more, so should the American people. And so I would urge not only that you support this amendment to make sure that you can handle the classified information, there's a mechanism for it, and the personally identifiable information that need not be public, but also information that is improperly classified, that bears and sheds light on your decision, should be accessible to you and should be accessible to the American people. And I reserve the balance of our time.
Mr. Cipollone?
Thank you, Mr. Chief Justice. Mr. Philbin, and then Mr. Sekulow will argue this.
Thank you, Mr. Philbin.
Mr. Chief Justice, members of the Senate, the President opposes this amendment, and I can be brief in explaining why. This amendment would say that any subpoena that was issued pursuant to the House's impeachment inquiry, that's any subpoena that they issued at all, becomes defined as a duly authorized subpoena for purposes of this amendment. And as we've explained several times today, because the House began this inquiry without taking a vote, it never authorized any of its committees to issue subpoenas pursuant to the impeachment power. The first 23 subpoenas at a minimum that the House committees issued were all unauthorized and ultra vires, and that is why the Trump administration did not respond to them and did not comply with them. That was explained in a letter of October 18th from White House counsel Pat Cipollone to Chairman Schiff and others. That is a legal infirmity in those subpoenas. There has never been an impeachment inquiry initiated by the House of Representatives against a President of the United States without it being authorized by a vote of the full House. And this is a principle that the Supreme Court has made clear in cases such as United States versus Roomley, that no committee of Congress can exercise authority assigned by the Constitution to the chamber itself, to the House or the Senate, without being delegated that authority by the House or the Senate. And in Roomley, the court explained that determining the validity of a subpoena requires, quote, construing the scope of the authority which the House of Representatives gave to the committee. So this is a legal issue, an infirmity in those subpoenas, and this amendment proposes to do away with that legal infirmity by defining all of their subpoenas as duly authorized. And we do not support that amendment. In addition to that, I would just want to respond briefly to Chairman Schiff's description of the rule of completeness. This is not about the rule of completeness. The rule of completeness has to do with if a particular document or particular piece of evidence is misleading in itself, that document, there's something specific about it, that there's another response on the email chain, something like that, that particular document has some specific thing attached to it, that should also come into evidence. But since all evidentiary motions are being preserved, objections can be made later, evidentiary arguments under the underlying resolution can be made. The rule of completeness can be argued. There's no need for that to do this amendment, because this amendment doesn't have anything to do with the rule of completeness. With that, I'll yield the remainder of my time to Mr. Sekulow.
Thank you, Mr. Chief Justice, members of the Senate. I'll be brief. This resolution, the amendment which we oppose, as Mr. Philbin just said, is in essence an unconstitutional attempt to cure a defect in their own proceeding. To be clear, we are reserving our objections as it relates to hearsay, which is what the record primarily consists of. I also want to respond very briefly to what Manager Schiff said regarding the proceedings in the House of Representatives and the lack of agency counsel. He said it's much like a grand jury. He best be glad, and the members of his committee best be glad, that it's not like a grand jury. Because if it was a grand jury and information was leaked, which it was consistently throughout this process, they could be subject to felony. So I want to be clear. Utilizing this amendment to cure a constitutional defect, and that's what this is exactly what we've been arguing about now for almost 11 hours. It's changing the rules. It's different rules. I can't determine if we are dealing with a trial, a pretrial motion, but we've now spent 11 hours arguing about something that we'll be arguing again next week. But the idea that you can cure in 3 paragraphs constitutional defects doesn't pass constitutional muster. We yield the rest of our time.
The House managers have 54 minutes remaining.
Well, first of all, counsel makes the argument once again that the subpoenas, the president gets to decide which are valid and which are invalid. And any subpoena the president doesn't like, he may simply declare invalid, and that's the end of the story. And therefore, it is invalid, and no documents are required, and no witnesses need show up. And therefore, you don't need to consider whether the president should be able to game the system by showing you a handful of documents to mislead you and deprive you of seeing all of the other documents relevant to that same subject. That's their argument. The president didn't like the way the subpoenas were issued. Even the court has already ruled on this issue and said, no, Mr. President, you don't get to decide whether a subpoena is valid or not in an impeachment proceeding. That's the sole responsibility of the House. But no, I guess they would suggest to you the president would never mislead you about documents. If they seek to introduce something, you can be assured that that document tells the complete truth. Well, we already know you can place no such reliance on the president. And how do we know this? You've already seen it. Look what they did in response to the FOIA, the Freedom of Information Act requests. They blacked out all the incriminating information. They blacked out the we can't represent anymore that we're going to be able to actually spend this money in time. We can't represent that we're not going to be in violation of the law, the Impoundment Act. They redact that. Is that what you want in this trial? For them to be able to introduce one part of an email chain and not show you the rest? You want to be able to have a situation where the president, who has withheld all these documents from you, can introduce a document that suggests a benign explanation, but not the reply that confirms the corrupt explanation. Because that's what we're really talking about here. Now, they clothe this in the argument, well, we don't think these were duly authorized subpoenas. We are merely categorizing the universe of documents they should turn over if they want to turn over selective documents. Let them call them unduly authorized, if they will. The point is that the documents that are called for should not be cherry-picked by a White House that has already shown such a deliberate intent to deceive. And finally, counsel says they can't tell whether we're dealing with a trial here. Well, you know something? Neither can we. And if they're confused for a good reason. Because this doesn't look like any other trial that they're used to, and people watching, they're confused too. Because they would think if this was a trial, there'd be no debate about whether the party with the burden of proof could call witnesses. Of course they can. Of course they can. The defendant doesn't get to decide who the prosecution could call as a witness. If you're confused, well, so's the public. They want this to look like a regular trial, and it should. That's been the history of this body. That's been the history of this body. Now, I know it's late, but I have to tell you, it doesn't have to be late. We don't control the schedule here. We're not deciding we want to carry on through the evening. We don't get to decide the schedule. There is a reason, though, why we are still here at, is that 5 till midnight? There's a reason why we're here to 5 to midnight, and that's because they don't want the American people to see what's going on here. They're hoping people are asleep. And you know, a lot of people are asleep right now, all over the country, because it's midnight. Now, maybe in my state of California, people are still awake and watching. But is this really what we should be doing when we're deciding the fate of a presidency? We should be doing this in the midnight hour? You know, I started out the day asking whether there could be a fair trial and expressing the skepticism I think the country feels about whether that's possible, how much they want to believe this is possible. But I have to say, watching now at midnight this effort to hide this in the dead of night cannot be encouraging to them about whether there will be a fair trial. I yield back.
Mr. Chief Justice,
The majority leader is recognized.
I have a motion at the desk to table the amendment.
Is there a sufficient
And ask for
second?
the ayes and nays.
There is. The clerk will call the roll.
Mr. Alexander. Ms. Baldwin. Mr. Barrasso. Mr. Bennett. Mrs. Blackburn. Mr. Blumenthal. Mr. Blunt. Mr. Booker. Mr. Bozeman. Mr. Braun. Mr. Brown. Mr. Burr. Ms. Cantwell. Mrs. Capito. Mr. Cardin. Mr. Carper. Mr. Casey. Mr. Cassidy. Ms. Collins. Mr. Coons. Mr. Cornyn. Ms. Cortez Masto. Mr. Cotton. Mr. Kramer. Mr. Crapo. Mr. Cruz. Mr. Daines. Ms. Duckworth. Mr. Durbin. Mr. Enzi. Ms. Ernst. Mrs. Feinstein. Mrs. Fisher. Mr. Gardner. Mrs. Gillibrand. Mr. Graham. Mr. Grassley. Ms. Harris. Ms. Hassan. Mr. Hawley. Mr. Heinrich. Ms. Hirono. Mr. Hoven. Mrs. Hyde-Smith. Mr. Inhofe. Mr. Johnson. Mr. Jones. Mr. Kane. Mr. Kennedy. Mr. King. Ms. Klobuchar. Mr. Langford. Mr. Leahy. Mr. Lee. Mrs. Loeffler. Mr. Manchin. Mr. Markey. Mr. McConnell. Ms. McSally. Mr. Menendez. Mr. Merkley. Mr. Moran. Ms. Murkowski. Mr. Murphy. Mrs. Murray. Mr. Paul. Mr. Perdue. Mr. Peters. Mr. Portman. Mr. Reed. Mr. Risch. Mr. Roberts. Mr. Romney. Ms. Rosen. Mr. Rounds. Mr. Rubio. Mr. Sanders. Mr. Sass. Mr. Schatz. Mr. Schumer. Mr. Scott of Florida. Mr. Scott of South Carolina. Mrs. Shaheen. Mr. Shelby. Ms. Sinema. Ms. Smith. Ms. Stabenow. Mr. Sullivan. Mr. Tester. Mr. Thune. Mr. Tillis. Mr. Toomey. Mr. Udall. Mr. Van Hollen. Mr. Warner. Ms. Warren. Mr. Whitehouse. Mr. Wicker. Mr. Wyden. Mr. Young.
Does any senator in the chamber wish to change his or her vote? If no, the ayes are 53, the nays are 47. The amendment is tabled.
Mr. Chief Justice.
The Democratic leader is recognized.
Mr. Chief Justice, I send an amendment to the desk to issue a subpoena to John Robert Bolton, and I ask that it be read.
The clerk will report.
The senator from New York, Mr. Schumer, proposes in amendment number 1291, at the appropriate place in the resolving clause, insert the following section: notwithstanding any other provision of this resolution pursuant to Rules 5 and 6 of the Rules of Procedure and Practice in the Senate when sitting on impeachment trials, the Chief Justice of the United States, through the Secretary of the Senate, shall issue a subpoena for the taking of testimony of John Robert Bolton, and the Sergeant at Arms is authorized to utilize the services of the Deputy Sergeant at Arms or any other employee of the Senate in serving the subpoena authorized to be issued by this section.
The amendment is arguable by the parties for 2 hours, equally divided. Mr. Manager Schiff, are you a proponent? Yes, I am. Mr. Cipollone, an opponent? Mr. Schiff, you may proceed. You may reserve time for rebuttal.
Before I begin, Mr. Chief Justice, the House managers will be reserving the balance of our time to respond to the arguments of the Counsel for the President. Mr. Chief Justice, Senators, Counsel for the President, the House managers strongly support this amendment to subpoena John Bolton. I am struck by what we have heard from the President's counsel so far tonight. They complain about process, but they do not seriously contest any of the allegations against the President. They insist that the President has done nothing wrong, but they refuse to allow the evidence and hear from the witnesses. They will not permit the American people to hear from the witnesses. And they lie, and lie, and lie, and lie. For example, for months, President Trump has repeatedly complained that the House denied him the right to call witnesses, to cross-examine witnesses, and so forth. You heard Mr. Cipollone repeat this lie today. Well, I have with me the letter that I sent as chairman of the House Judiciary Committee last November 26th, inviting the President and his counsel to attend our hearings, to cross-examine the witnesses, to call witnesses of his own, and so forth. And I have the letter, the White House letter, signed by Mr. Cipollone, rejecting that offer. We should expect at least a little regard from the truth from the White House, but that is apparently too much to expect. Ladies and gentlemen, this is a trial. At a trial, the lawyers present evidence. The American people know that. Most 10-year-olds know that. If you vote to block this witness, or any of the evidence that should be presented here, it can only be because you do not want the American people to hear the evidence, that you do not want a fair trial, and that you are complicit in President Trump's efforts to hide his misconduct and hide the truth from the American people. Ambassador Bolton was appointed by President Trump. He has stated his willingness to testify in this trial. He is prepared to testify. He says that he has relevant evidence not yet disclosed to the public. His comments reaffirm what is obvious from the testimony and documents obtained by the House, which highlight Ambassador Bolton's role in and repeated criticism of the President's misconduct. In fact, extensive evidence collected by the House makes clear that Ambassador Bolton not only had first-hand knowledge of the Ukraine scheme, but that he was deeply concerned with it. He described the scheme as a drug deal to a senior member of his staff. He warned that President Trump's personal lawyer, Rudy Giuliani, would, quote, blow everybody up, unquote. Indeed, in advance of the July 25, 2019 call, Ambassador Bolton expressed concern that President Trump would ask the Ukrainian president to announce these political investigations, which is, of course, exactly what happened. Now, of course, there were to be no investigations. All he cared about was an announcement to smear a political rival in the United States. He repeatedly urged his staff to report their own concerns about the President's conduct to legal counsel, that is, Ambassador Bolton did, not the President, as the scheme was unfolding. Finally, as National Security Advisor, he also objected to the President's freezing of military aid for Ukraine and advocated for the release of that aid, including directly with President Trump. And of course, as we all know, the Impoundment Control Act makes illegal the President's withholding of that aid after Congress had voted for it. But the President ignored the warnings about that because all he cared about was smearing a political rival. The law meant nothing to him. Ambassador Bolton has made clear that he is ready, willing, and able to testify about everything he witnessed. But President Trump does not want you to hear from Ambassador Bolton. And the reason has nothing to do with executive privilege or this other nonsense. And the reason has nothing to do with national security. If the President cared about national security, he would not have blocked military assistance to a vulnerable strategic ally in the attempt to secure a personal political favor for himself. No, the President does not want you to hear from Ambassador Bolton because the President does not want the American people to hear firsthand testimony about the misconduct at the heart of this trial. The question is whether the Senate will be complicit in the President's crimes by covering them up. Any senator who votes against Ambassador Bolton's testimony or any relevant testimony shows that he or she wants to be part of the cover-up. What other possible reason is there to prohibit a relevant witness from testifying here? Unfortunately, so far I've seen every Republican senator has shown that they want to be part of the cover-up by voting against every document and witness proposed. Ambassador Bolton is a first-hand witness to President Trump's abuse of power. As the National Security Advisor, he reported directly to the President and supervised the entire National Security Council. That included 3 key witnesses with responsibility for Ukraine matters who testified in great detail before the House: Dr. Fiona Hill, Tim Morrison, and Lieutenant Colonel Alexander Vindman. Moreover, in his role, John Bolton was the tip of the spear for President Trump on national security. It was his responsibility to oversee everything happening in the Trump administration regarding foreign policy and national security. By virtue of his unique position, appointed by the President, Bolton had knowledge of the latest intelligence and developments in our relationship with Ukraine, including our support of the country and its new President. And that is why the President and some members of this body are afraid to hear from Ambassador Bolton, because they know he knows too much. There is also substantial evidence that Ambassador Bolton kept a keen eye on Rudy Giuliani, who was acting on behalf of the President in connection with Ukraine. As we will describe, Ambassador Bolton communicated directly with Mr. Giuliani at key moments. He knows the details of the so-called drug deal he would later warn against. Perhaps most importantly, Ambassador Bolton has said both that he will testify and that he has relevant information that has not yet been disclosed. A key witness has come forward and confirmed not only that he participated in critically important events, but that he has new evidence we have not yet heard. That is precisely what Ambassador Bolton has done. His lawyer tells us that Ambassador Bolton was, quote, personally involved in many of the events, meetings, and conversations about which the House heard testimony, as well as many relevant meetings and conversations that have not yet been discussed in the testimony thus far, close quote. Ambassador Bolton was requested as a witness in the House inquiry, but he refused to appear voluntarily. His lawyers informed the House Intelligence Committee that Ambassador Bolton would take the matter to court if issued a subpoena, as his subordinate did. But the ambassador has changed his tune. He recently issued a statement confirming that, quote, if the Senate issues a subpoena for my testimony, I am prepared to testify. So the question presented as to Ambassador Bolton is clear. It comes down to this. Will the Senate do its duty and hear all the evidence? Or will it slam this door shut and show it is participating in a cover-up because it fears to hear testimony from the former National Security Council Chairman, the former National Security Advisor of the President, because it fears what he might say. It fears he knows too much. Consider this as well. Why is President Trump so intent on preventing us from hearing Ambassador Bolton, his own appointee, his formerly trusted confidant? Because he knows his guilt, and he knows that he doesn't want people who know about it to testify. The question is whether the Republican senators here today will participate in that cover-up. The reasons seem clear. President Trump wants to block this witness because Ambassador Bolton has direct knowledge of the Ukraine scheme, which he called a drug deal. Let's start with the key meeting that took place on July 10th. Just 2 weeks before President Trump's now famous July 25th call with President Zelensky, Ambassador Bolton hosted senior Ukrainian officials in his West Wing office. That meeting included Dr. Hill, Lieutenant Colonel Vindman, Ambassadors Sondland and Volker, and Energy Secretary Rick Perry. As they did in every meeting they took with U.S. officials, the Ukrainian officials asked when President Trump would schedule a White House meeting for the newly elected Ukrainian president, because it was very important for the Ukrainian president, a new president of an embattled democracy, being invaded by Russia, to show that he had legitimacy by a meeting with the United States. Dr. Hill testified that Ambassador Sondland blurted out that he had a deal with Mr. Mulvaney for a White House visit, provided that Ukraine first announce investigations into the president's political rivals. Ambassador Bolton immediately stiffened and ended the meeting. Dr. Hill's testimony is on the screen. In other words, Ambassador Bolton and others at the meeting, they were interested in the national security of the United States. They were interested in protecting an American ally against Russian invasion. They couldn't understand why this sudden order was coming from the president to abandon that ally, because they didn't yet know. They didn't yet know of the president's plot to try to extort the Ukrainian government into doing him a political favor by announcing an investigation of a political rival. When Dr. Hill reported back to Ambassador Bolton about the second conversation, Ambassador Bolton told Dr. Hill to go to the National Security Council's legal advisor, John Eisenberg, and tell him, quote, I am not part of whatever drug deal Sondland and Mulvaney are cooking up on this. Here is an excerpt of her hearing testimony.
A specific instruction was that I had to go to the lawyers, to John Eisenberg, our senior counsel for the National Security Council, to basically say, you tell Eisenberg, Ambassador Bolton told me, that I am not part of this whatever drug deal that Mulvaney and Sondland are cooking up.
What did you understand him to mean by the drug deal that Mulvaney and Sondland were cooking up?
I took it to mean investigations for a meeting.
Did you go speak to the lawyers?
I certainly did.
These statements and events are reason enough to insist that Ambassador Bolton testify. He can explain the misconduct that caused him to characterize the Ukraine deal, the Ukraine scheme, as a drug deal, and why he directed his subordinates to report their concerns to legal counsel. He can tell us everything else he knows about how Ambassador Sondland, Mr. Mulvaney, and others were attempting to press the Ukrainians to do President Trump's political bidding. Once more, only Ambassador Bolton can tell us what he was thinking and what he knew as the scheme developed. That is why the President fears his testimony. That is why some members of this body fear his testimony. Ambassador Bolton's involvement was not limited to a few isolated events. He was a witness at key moments in the course of the Ukraine scheme, and especially in July, August, and September last year. I would like to walk through some of those events. Please remember, as I'm describing them, that this is not the entire universe of issues to which Ambassador Bolton could testify. Only examples that show why he is such an important witness and why the President is desperate to block his testimony. We know from Ambassador Bolton's attorney that there may be other meetings and conversations that have not yet come to our attention. But to take one example, we know from witness testimony that Ambassador Bolton repeatedly expressed concerns about the involvement of President Trump's personal lawyer, Mr. Giuliani. In the spring and summer of 2019, Ambassador Bolton caught wind of Mr. Giuliani's involvement in Ukraine and soon began to express concerns. Ambassador Bolton expressed strong concerns about Mr. Giuliani's involvement in Ukraine matters. When Ambassador Bolton described Mr. Giuliani as, quote, a hand grenade that was going to blow everybody up, unquote, it was based on his fear that Mr. Giuliani's work on behalf of the President, his attempts to have Ukraine announce these investigations, these sham investigations, and his campaign to smear Ambassador Yovanovitch would ultimately backfire and cause lasting damage to the President. It turns out he was right.
Did your boss, Ambassador Bolton, tell you that Giuliani was, quote, a hand grenade?
He did, yes.
What do you think he meant by his characterization of Giuliani as a hand grenade?
What he meant by this was pretty clear to me in the context of all of the statements that Mr. Giuliani was making publicly, that the investigations that he was promoting, that the storyline he was promoting, the narrative of he was promoting was going to backfire. I think it has backfired.
In June, as Ambassador Bolton became aware of Mr. Giuliani's coordination with Ambassadors Volker and Sondland, he told Dr. Hill and other members of the National Security Council staff that, quote, nobody should be meeting with Giuliani, unquote. But he, of course,